Before we start today's webinar, I wish to acknowledge the traditional custodians of this land and their elders past and present. For those who don't know me, I'm Tim Sheehan. I'm one of the partners at GWI, and you have several hosts today. One of other hosts from GWI is Dr. Vanessa Douglas-Savage, and we have some special guests joining us today from Queensland State Archives, Troy Pullen and Julie Shanks. Before I hand over to our hosts, I have a couple of announcements. Today's presentation will run about 40 to 45 minutes, so that will leave plenty of time towards the back end for us to cover off some key questions and maybe cover off on some other questions that you have. If I please ask that everyone kind of goes on mute, so we don't all talk over the top of each other, and you can just leave your questions via the chat function. I'll now hand you over to both Troy and Julie, who will start off today's proceedings.
Cool. Thanks, Tim. So we just to start with, we thought we might go into a little bit of background into what led to the development of the QSA advice for the proactive protection of vulnerable persons. And also just a disclaimer right up front that we don't have all the answers today, so just in case you're looking for that. But we do have some scenarios that we'll go through a little later on, and hopefully that might put the advice in a little bit of context for these different scenarios. Okay, so if we just look at the next slide. Cool. Okay, so I'm sure a lot of people are probably aware that the advice was initially drafted in response to recommendations 8.1 to 8.4 from the Royal Commission into Institutional Responses to Child Sexual Abuse, or RECRSCA, as we call it. The recommendations require that records relating to child sexual abuse that has occurred or is alleged to have occurred are retained for at least 45 years, that disposal authorisations reflect this, and that the guidance is developed to help public authorities identify these relevant records. The RECRSCA report was significant for record keeping in that an entire volume was dedicated to record keeping and information sharing. And to us and to everyone, that just highlighted how important the role that record keeping had and continues to have in keeping people safe. And, you know, not just children, but all people that public authorities interact with, including vulnerable persons. And we found that while we were developing advice, there were a number of other initiatives happening across government and the community as a whole that was relevant, and really resulted in our advice being broadened to include vulnerable persons in all forms of and all forms of abuse. So, for example, in response to the RECRSCA, the National Redress Scheme was established. And this scheme has direct implications in terms of, you know, information that's being requested by survivors of abuse and the records which have been kept and maintained by agencies to support these redress claims. In response to other recommendations made by RECRSCA, there's been a number of other legislative amendments that have been introduced, and these changes aim to improve the capacity of the justice system to provide fair access to and outcomes to people who wish to pursue a claim for civil damages and for personal injury arising from abuse experienced as a child. And so, to go into some more detail about these, a number of legislative amendments impose new statutory duties on agencies, including reversing the onus of proof onto institutions to be able to take all reasonable steps to prevent child sexual abuse and serious child physical abuse while the child is under the care, supervision, control, or authority of the agency. So that's a real key one, I guess, you know, to think about in terms of record keeping, is for an agency to be able to prove what processes they may or may not have had in place to care for people under their supervision. Further, a primary focus of the Royal Commission was to create child safe standards, and with many recommendations coming out of the report directed at achieving this goal. And this had obvious implications in terms of, you know, the type of records that need to be kept and maintained. And finally, to throw into the mix while we were drafting and consulting and all this, is the introduction of two new Royal Commissions. So there's one Royal Commission that was into the violence, abuse and neglect of people with disability, and the other Royal Commission into the aged care sector. And really, while the final recommendations and report hasn't been released for these Royal Commissions yet, they're still ongoing, both of which could reasonably be expected to contain similar findings to the RECRSCA. Notably, in that without accountability, full and accurate, complete and reliable records, an environment in which abuse can occur is possible. So in addition to responding to the initial recommendations from RECRSCA, we've come a fair way. So our advice also gives a little bit of record keeping context to all of these related initiatives that have been happening across government over the past year or two. Okay, so I'll now hand over to Vanessa, and she'll outline a few different scenarios and how advice kind of might apply in each of those scenarios. So over to you, Vanessa.
Fantastic. Thanks so much, Troy, and welcome everyone.
Vanessa, just before you get started, I forgot to make an announcement that this session is recorded today. So if anyone would not like to join due to that reason, I please ask you to leave the session.
Perfect. Thanks, Tim. Hey, so thanks for joining us today, and thanks, Troy, for that great introduction. From our perspective, so GWI.
It's on here. Hey? It's on here.
Oh, mine just had a TP.
Look, you.
Sorry, can we go just jump on me? Thanks. GWI, obviously information and data specialist. So we spend a lot of time with people talking about their information and data. And we were really excited to see this particular guideline be released. From our perspective, the capturing of records relating to vulnerable people is really one function of information governance. And so from our perspective, information governance is really about the rights and accountabilities for what you can do, what you should do, and what you must do with information and data in your particular organisation. Given the current focus on records of vulnerable people, it's obviously pretty tempting to dive right in and to start considering the entirety of records that could be created and potentially go down the track of boiling the ocean. And so as Troy mentioned today, what we've done is we've put together 4 different scenarios with some advice about how to get started in these spaces. So rather than it's giving you a starting point to be able to move on from. So information governance obviously plays a really important role in ensuring that these records are created, because it's all about ensuring that they're captured correctly and that they're kept for as long as necessary. And I think everybody here would agree that we all have a responsibility to care for the most vulnerable in our society. And that, sometimes it's quite easy to identify who might be vulnerable. Children under 18 years of age, those with certain disabilities or are obviously quite straightforward, but it also covers off obviously any adults that don't have the capacity to make their own decisions. Now, Troy mentioned a range of different inquiries, both recent and ongoing. And as he mentioned, one of the common themes out of these inquiries has really been around the way that information is shared, the way that it's moved between organisation, and how those controls have been exercised. And so ensuring the records of vulnerable people are captured is focused for everyone, not just those organisations that have a really obvious role to play here. It's pretty easy to think about child safety organisations, for example, but as you can see from the examples we give you a little bit later, it applies to nearly every organisation in society that deals with people. The machines are not here yet. And I think we'd all agree that doing this is not only legislatively required, but it's also the right thing to do to care for the most vulnerable. So I've got 4 sector-based examples that I'm going to talk you through today, and I'm going to show how you can use a risk-based approach to really inform record keeping and the types of records that you collect in those areas. So the first sector we'd like to look at is around aged care, and obviously this one's a little bit topical because of the current Royal Commission. But outside of that Royal Commission, the aged care is actually also involved in a huge transformational agenda, and the way that it uses information and data is changing quite rapidly. The changes in the aged care sector are also relevant for those government organisations that intersect or interact with these organisations, so regulators, for example, but also going all the way through to, for example, insurers. In this scenario, we'd really probably consider the focus of vulnerable people to be the elderly themselves, but it might also include their families, especially when their families are also carers. So they'll also have some vulnerabilities and some records that'll need to be kept about those interactions. And really, when we're interacting with these aged care sectors, what we're seeing are issues around the collection and use of data, because it is transforming so rapidly, as well as the ability to respond to inquiries. Obviously, that's top of mind at the moment, given the number of inquiries that are ongoing and some of the findings of the ones that have been done in recent years. And so really, if we start thinking about the collections around the risks around collection and use, the one at top of mind at the moment, and probably because of COVID, is really around privacy. And so making sure that those records are captured in a privacy sensitive way, so using a privacy by design approach. And to help think about how you might do this, what we really recommend is that you actually capture records around the decisions about how privacy legislation has been interpreted and applied. Privacy is a really interesting area, and capturing records with personal information is really quite complicated because there are no black and white scenarios. If you've ever dealt in the privacy space, you'll know that personal information is contextual. And so it can be quite difficult to give that single answer about what exactly is or isn't personal information. But one of the pieces of advice that serves our clients really well is to understand and have a framework for making those decisions. And then make sure that any decisions about documenting information, whether it's in a new system, whether it's around an RTI release, for example, are then captured and documented as well. Now, obviously, one of the other risks for this particular sector is around legislative responsibility. And in general, this is done pretty well. I'll be honest with you, most people meet their legislative and regulatory responsibilities. The key here, though, of course, is to make sure that you've got all of that covered off in your retention disposal schedule. So there has been some change relatively recently. And so making sure, looking at retention disposal schedule, making sure it actually reflects what community expectations are around those vulnerable people and keeping of those records is really important. Finally, I think for this particular sector, there's also some issues in how you collect and use data in grey areas. And I think the pandemic's a great example of this space in itself. So at the moment, we're being forced to collect and use data in new ways to be able to respond and ensure that we all stay healthy and safe in this particularly interesting time. And again, part of the key to capturing records around vulnerable people in this time is not just capturing the records themselves, but also capturing why those decisions were made. Why did you choose to keep that gamut of information, or why did you choose not to collect some other section of information? What we always say is that having a process is better than not having anything at all. And so being able to say to a commission, this is the process that we used. You can then be criticised, obviously, on the process itself, but at least you've got a consistent way to be able to work through things. Being able to really understand why events happened is the key, and we feel, for this sector. One of the things just to be aware of too, of course, because this sector is undergoing so much transformational change, is there may be a need to increase your digital literacy. And so one of the challenges in capturing records in this sector is really the fact that perhaps not everyone is actually skilled in understanding what is a record, how it could be defined, and where it should be stored. And so that's one other particular area to look at once you have made some decisions around what might be collected, would be to look at, well, do staff actually have the skills and capabilities to do that? And how do we make it as easy as possible? So Michelle, can we flick to human services? Thanks. So the second sector we're going to look at is human services. And for me, this is the one that's really obvious. Like, everybody thinks of human sectors when you're thinking about capturing records of vulnerable people. So for example, child safety, youth justice, domestic and family violence, they all spring to mind quite readily. And we can all see a really straightforward link to the vulnerable people in those scenarios. Now, we want to acknowledge many of these organisations have really well-defined rules around capturing and retaining records, and they're also on top of managing them day to day. And in this instance, we're really probably talking about the vulnerable people being children and all young people, their families and carers, or victims and perpetrators that have come forth for assistance. For this sector itself, though, really we're seeing two main issues play out with our clients. The first one is a big digital systems agenda. So in many ways, much like the aged care sector, there's a large digital transformation taking place in this sector, where workers are getting access to be able to create records at the place where they occur. So, for example, in the child safety space, that's the ability to actually capture records while they're at site, while they're actually sitting with a child or with that child's family. And one of the risks at the moment, though, of course, is that that's really hard. Like, it can be really tricky to have a system that works both online and offline and then make sure that appropriate records are captured. So capturing records in a timely manner and also capturing the really rich context that comes with a record around a vulnerable person in this sector is quite challenging. I think increasingly, and while this isn't happening yet, I think increasingly we're going to see more visual and verbal records being captured as a matter of course to be able to give that additional context. But when we're thinking about capturing records in this particular scenario, we really make recommendations around automating and capturing once and using for many, many different purposes, none of which will be a surprise, I'm sure, to most people on this call. So in some organisations, this means actually putting in place automated flows so that information gets captured in one system and automatically flows into a record keeping system in another. It's taking the burden off the end users so they don't think about capturing a record as a separate activity to their day-to-day work. All of us have different passions, and particularly in the human services sector, whether you're talking about teachers or child safety officers or anyone working in the courts, for example, that's their first passion. Unfortunately, record keeping is not always their second passion. And so this really, when we're talking about digital systems, we're talking about making it simple and easy for people to use. Increasingly, we're also seeing some people start to dabble around the edges with artificial intelligence in this space. So using AI to actually flag when a record might be about a vulnerable person. It's a really interesting area, but it's also quite fraught with danger around information bias and algorithm bias. So automation and integration are really the key in this particular sector that in terms of ensuring you capture full and accurate records of vulnerable people. The integration can be key. Most of our organisations use systems that were designed 10 years ago, so it's they're getting quite aged at the moment. And unfortunately, back in the early 2000s, we didn't design systems for data sharing or data integration. Increasingly, we're seeing more and more work done to actually integrate those systems together to make the process of capturing records of vulnerable people as simple as possible. Now, one of the other interesting aspects that we just want to acknowledge in this sector is also that often records aren't available. So they might have been destroyed and destroyed lawfully. I need to emphasise in this space, in line with retention and disposal schedules. One of the challenges we're actually seeing in this particular sector is that in some cases, some practices might be out of step with community expectations. Now, this is a pretty common theme in many different government service delivery organisations. Yeah, are we doing what people expect us to do? It's the old change your address with one agency and make sure everybody knows about it, right? We still don't have a clear solution to it. And similarly, we still don't necessarily have a clear solution to knowing exactly what records a Royal Commission or an inquiry might be looking for. But the advice we provide our clients is that if you're consistently reviewing and actively managing your retention disposal schedule, actively managing according to the different reviews that are currently being published, being proactive about that, then you're probably going to be in a pretty good spot to be able to respond to any future inquiries and to ensure that those vulnerable people can have access to their records in the future. All right, let's do criminal services. And this one is particularly fascinating. It relates to some work that we've just wrapped up quite recently. And in this particular scenario, we want to actually focus on a current trend, and that trend is around video footage. So increasingly, we're seeing CCTV or body-worn cameras come into our service delivery organisations. And it's not uncommon for some people in that sector to be wearing those devices 24 hours a day. We tend to see there are two different extremes that in this particular sector and based around video footage. One is that everything is kept. So we capture records, and because storage has gotten quite cheap in many cases, we keep those records for as long as humanly possible. So there's no formalised approach to how they're going to be deleted, managed, where they're going to be kept, for example. And sometimes those decisions are devolved down to, for example, the providers. The provider might say, oh, well, we keep these for 5 years. Is that fine? Oh, yeah, that's cool. Obviously, if you keep everything, though, it's really difficult to find everything. And so it's a really interesting point. You might actually have the record, but can you actually discover it? And if you can discover it, what's it going to cost? How much time is it going to have? And what liabilities are you exposing yourself to unnecessarily? So we all know, because we've all got a record keeping background here, keeping records you don't have to is a bad idea. Keeping records of video just because you can is also a bad idea. And it's something that I don't think some organisations haven't completely thought through. At the other extreme, we see some organisations in this sector just overwriting files. So saying, you know what, we keep it for 2 weeks. After 2 weeks, we just delete it. And we had an example of that where I live at the moment with our body corp, where they overwrite their tapes every 4 weeks. And someone had a bike stolen from out the front, as is also very common, I must say, in this particular area. And they went to the police, reported it, did everything. But then when the police, because obviously a single bike being stolen isn't a high priority in many instances, by the time police got around to making inquiries, obviously that footage had already been deleted, and so it wasn't available to inform any sort of investigation. That sort of activity, especially in a public sector organisation, obviously is not ensuring that you're keeping full and accurate records. It's unlawful destruction, and so obviously it's got some challenges and shouldn't be done. You can see how both extremes, probably most organisations sit in the middle. Most people would probably have somewhere in the middle where they understand and actively manage some video records, but not necessarily all of them. It's a really hard one to get your head around though, because video and photos as well are such a rich medium. They're such an interesting, rich medium, and we can all relate to it really easily. There's nothing like seeing someone on a screen to capture your attention. And so I think video is also at that stage where we think, oh, we better just keep it just in case. Digital hoarding, I like to call it. Obviously, it's not sustainable though, not sustainable, and it's not good practice. And so in terms of the advice we give our clients around what to do, we really say look at the intersection of vulnerable people and video. And in this scenario, vulnerable people are probably not just the people in the criminal services system, but also your staff. So the vulnerabilities of staff in this particular scenario also count. So if you can look at that intersection of who might be vulnerable and what sort of video footage you might have, then you can start to use your agency's risk profile, the agency services profile, to start to understand where its intersections occur and what information might need to be kept. Now, depending on the organisation and depending on the complexity, you may actually choose to keep, it may be more difficult to not keep some information than to actually just keep it. So you may choose to, for example, keep all information even though you're only interested in a certain proportion of it, and we certainly acknowledge that. This is, though, one of the things we'd say is this is one of a relatively rapidly evolving area. So it's something to keep an eye on, to have an active management plan. And so you see that theme from the other scenarios too, obviously. Yeah, it's about that active management, being on top of it at different times. The other thing we recommend when you're managing records of vulnerable people that are video-based is to look at community expectations. Now, these can often be a little bit different to our own internal expectations, and that's quite rightly so, because obviously the public doesn't necessarily know all of the details of a particular service or how that service is delivered. But community expectations are also an important spot where it might be able to help inform some of the grey areas. So, for example, if you're on the fence about how much of a particular video footage you keep, but you think more from a community perspective, they'd probably expect that we keep all of it, or from a community's perspective, actually they got no idea. That might help you make a decision. RTI requests and also any illegal requests can also be a really useful source of information to help understand what you need to keep around vulnerable people in this area. However, what we do say is having a decision is better than no decision. So not making a decision is a decision not to make a decision, we always like to say. So having a decision, making sure that it's written down and making sure it's reviewed regularly and appropriately signed off is a really important piece of the information governance puzzle for records of vulnerable and young people. Vulnerable people, sorry. So finally, onto the final sector, and this one was a little bit fun to play around with. The final sector we're going to look at is local government. And the reason we chose this local government sector is really because in the work we do, local governments are the front line of government services. They're probably this place where we are most likely to touch government services in a day-to-day context, whether it's just simply paying for your parking meters, which if you're in Brisbane, remember parking meters are back on now. But there's also the libraries that people interact with, our local shopping precincts and so forth. It's a really difficult one to unpick, I'll be honest with you, because of the breadth and the depths of services that local governments actually collect. And it's further complicated by the expectations around data sharing and around community expectations that, well, just because I've told my local council, why aren't you putting me in touch with the right people in state government? Why aren't you sharing with them? So often these records of vulnerable people might be captured by local government but used by many different tiers of government. Honestly, in this instance, pretty much any definition around vulnerable person can apply. And while in the other scenarios we can pin down a vulnerable person's definition reasonably easily, in this scenario, what we tend to recommend is that actually understanding where to start, you need to understand the services first and foremost. So So understanding the high-risk services that a council is actually providing, whether that's around a local fete specifically designed for vulnerable people, whether it's around how accessibility is managed in a library, or something to do with parking meters, although I'm not quite sure what that would be. In most instances, your councils will actually have done a lot of work on understanding the risks around these services, and that can be a really useful starting point to say, well, if these are our high-risk services that the council's currently offering, where might vulnerable people be interacting with these services, and then what sort of records would I need to keep? The other area we always recommend to focus on is really high volume services. So if you've got a high volume of services, chances are that a subsection of people interacting with those services are going to have some vulnerabilities, and so that can be another way to at least start to unpick this particular problem. In this sector too, we really see some risks around reputation. So reputational risks around why hasn't council collected certain types of records, shouldn't they have known? Now, there's no way of predicting the future, unfortunately, otherwise none of us would have predicted 2020 would have quite played out like it has. None of us would have bought 2020 diaries, I'm sure. But there's a couple of ways we can start to almost provide a piece of insurance to ensure that you do capture the right records. First and foremost, you can look at what other people are doing. So looking at bigger councils, if you're on a small council, looking at bigger councils, if you're in a big council, look at some of the smaller councils, because in some instances they will actually have more interactions with vulnerable people. What are they doing? What isn't being collected? What are the decisions being made? There's some great forums out there, some peer-to-peer forums. I know in Queensland where people share that sort of information, so they can be a great starting point. And also then, of course, if we share, we can actually increase the capability across the sector. Now, you probably heard me say this enough already, but also capturing records about the decisions that are made, about the records that will be kept about vulnerable people is really important. So making sure you explicitly have a framework for making those decisions, and that when that framework is applied, that you capture the decisions out of that framework is really important. And it's especially important in this sector because of the breadth and the depth of services that are actually provided. So they're the 4 scenarios that we wanted to run through today. And just finally, I just wanted to emphasise that the common denominator when we're talking about records of vulnerable people is really to show that you've considered and that you've got a process. So across all of the different sectors, that's really what we're talking about here, is find somewhere to start, get some executive buy-in on that particular approach and that starting point, and then being able to capture the decisions relating to that approach. So having an explicit process that meets your legislative, regulatory and community expectations is really the key, we feel, in this instance. Starting with something is better than not having anything. So like I said before, the decision to not have anything is still a decision. So while it might seem like it's a really difficult thing to unpack, we'd recommend just picking one area and starting there. The other common denominator, hopefully, that you've picked up here is really about leveraging existing tools, whether that's the existing risk register, whether it's the existing information governance group, whether it's just a cohort of service delivery people who get together. Most people have a really good feel for where the vulnerable people might be interacting with their services and what sort of records could be created. And similarly, ensuring that you capture those records and use them many different times rather than simply asking people to capture more about a particular interaction is really important. But hopefully with those ideas, you'll be able to identify a few areas and take away a few tips and tricks from our experience to ensure that you do actually capture those records of vulnerable people. So at this point, what we thought we'd do, obviously, if you've got any questions, please throw them into the chat box. But we actually pulled out the 3 most common questions that we get asked and that we hear. So in conjunction with QSA, and Troy and Julie, I'm going to ask you these questions. I'm going to do this little interactive Q&A. Probably the most common question we get asked is simply, do I have to keep everything? Does this mean every interaction with a vulnerable person I've got to keep a record of?
Hi, Vanessa. Julie from QSA. So we would say no. QSA is not suggesting to keep every record forever. Because if you do that, you've got to store them, you've got to find what you need, and you've got to reuse it. So that is not what QSA is saying. And before I answer other questions, I have to say that we don't have a magical list of documents that we can give all agencies and say, if you keep these 20 documents, you'll be fine. Because it doesn't work like that. It needs to be considered on an agency by agency basis to work out what your risks are and which records you should keep.
Yeah, absolutely. And it's never, like you say, it's never simple. There's always some really easy ones I always like to think of. There's some really hard ones, and then there's that difficult grey spot in the middle where it's it takes a little bit more effort to work out exactly what you need to do. So from that perspective, what do I actually have to do if I'm a new record keeper in an organisation and I'm looking at records of vulnerable people? What do I have to do, Julie?
Okay, so we would start by saying that this isn't just a records management issue. It's across the agency and it's a strategic risk. So it's not something that we expect you in your records office to solve for the agency entirely. It needs to be across agency responsibility. So we did write to all CEOs of public authorities and to records areas on the 27th of March, telling people about the guidelines, the disposal authority, and that the disposal freeze was lifted. So your CEOs know that there have been changes, and we've also wrote during the consultation period, so they're aware of this issue. So organisations need to think about who has primary responsibility for this issue, where does it rest, and where should the drive come from to deal with it. But records areas need to be involved. And maybe in some organisations, the records areas will drive it, but you can't do it by yourself. You need to look at whether another area is driving. So is the risk management area going to lead the way and you participate? And maybe if you're not sure, go out and talk to other areas, or if no one else is doing it, maybe it's time to brief up or have a discussion. You know, refer to our letter and say, we've got some responsibilities that we need to deal with and we need to be a good corporate citizen. So you need to look at, in terms of within your agency, like, is there a risk management area? Is there a legal area? HR should be involved. Internal audit. So if you're a department or a statutory body, the Financial Accountability Act actually says that the head of internal audit has to provide assistance with risk management. So perhaps they need to be involved. And you also need the business owners who interact with the vulnerable people, because they know how the processes work and what you might need to look at. And so the way you deal with it might be different from agency to agency. So someone like Gasfields Commission has about 9 employees. So the way they deal with it is going to be different to the way a department or a local government manages it. You also need to look at your agency's risk management framework. And if you're having some issues sort of understanding more about risk management, I'd also suggest, and we refer to it in the guidelines, the Queensland Treasury has a risk management guideline, which is useful as well. The agencies need to think about their risk appetite. Obviously, this is a sensitive issue and the consequences are significant. So you need to be really thinking about that. But think about your agency's risk tolerance as well. In terms of steps that your agency takes to work out what records you need to keep, you need to look at what functions do you offer? What functions do you offer and where do you interact with vulnerable people? So highlight those interactions and then delve deeper and go, what's our risk with these actions? So, for example, at QSA, we have a search room where the public can come in and search. And we also do tours for people. We have a memory lounge for dementia sufferers. So we'd look at where do we have interactions with vulnerable people there. Children can come into the search room. Children can be on tours. We also have volunteers, potential work experience, whether we have young uni students. We look at all of those and work out where are our interactions with those people. And once you've done that, you need to assess the level of risk of abuse occurring there. So, for example, is there a lot of one-on-one interaction versus group interaction? Because your risks are likely to be lower with the group interactions. So, for example, lots of councils own a swimming pool And even if they contract it out, it's still their responsibility. So one-on-one swimming lessons, in what way can we make sure risks are lowered there versus group swimming lessons, or a council library where, you know, they're reading books to children? You know, what way do you manage your risks? Parents are in there, there's no one-on-one. How do we look at it? Local governments also have aged care homes, so they need to look at that as well, because there's potentially, you know, lots of one-on-one contact there in terms of toileting and showering, things like that. And then you need to look at what actions you can take to mitigate those risks, to try and prevent harm. So, you know, in the swimming pool scenario, do you always require a child to be accompanied by an adult? Do you have CCTV footage? Do you only do group lessons? Do you do training? Do you keep records about everything? So there's different actions, and that's obviously not all the treatments that there are, but there's different ways you can try and mitigate your risks. And this is why I'm saying this isn't a records area, because this is much broader across the agency and it's for a whole heap of people to come together and solve. But the highest priority needs to be given to the risks that are least acceptable, with the not good outcomes potentially. But we have to recognise too that some risk is acceptable. We can't wipe out every risk because we don't all have the budget for that. So some risk is unavoidable. You also need to look at the cost benefits sometimes to look at that. So for example, in a hospital, you know, one way to prevent it could be to have two doctors always, or two people in a room with a child, but we can't always do that and we don't have the resources. So that's not going to be the answer. And on an ongoing basis, you need to keep monitoring and reviewing your risks so you're keeping up to date. It's not a set and forget. I also wanted to add that the process that you go through in developing what records to keep is really important, and those records that you create during that process is really important, because that's your governance practices. That tells people how you came up with that answer and what you're going to do with your approach going forward. So if something happened in the future and there was a court case, or you had to go to a Royal Commission and say, you know, so what records did you keep and why? You've got a justified reason where you've considered what your approach was and it's come out that way, rather than, you know, doing nothing and hoping for the best. So just remember, as Troy said, that there is that other legislation. So this isn't just about QSA saying you need to do it. There's the other legislation, the Civil Liabilities Act, which started in March, which reverses the onus of proof for organisations. So instead of it being, so if I was abused, I have to try and prove that it happened. They've reversed the onus of proof for the agency to have to try and show that it didn't happen. So, and that you took reasonable steps to avoid it. So there's more information in the explanatory notes about what reasonable steps are, but your reasonable steps are some of the practices and approaches too that you're taking to try and prevent it, and determining what records help in that case. The legislation, when they were developing it, they also recognised one reason they reversed the onus of proof is because there's a power imbalance. So there's a power imbalance between the vulnerable person and your organisation. So that's why the requirement for more record keeping is an element and is your responsibility because of that power imbalance. So, and it's also obviously important to keep the records about potential and allegations of abuse, as well as the corroborating evidence that you've worked out in your risk assessment. So the solution isn't just to keep all the records, and that even if you did that, that doesn't help solve the problem of preventing the abuse in the first place. So it's not the answer, and it doesn't reduce the risk as much. So, and it helps explain why this is a whole of agency issue and not just a records management issue.
I think you're spot on there, Julie. I think that's really important. Hey, we had another question in here, which was when do I have to do it by? Like everything, it's probably yesterday, and yet it's got to be worked into forward work programs. But what we might do, so Julie, Troy, do you have a quick answer? When does all this need to be done by?
Okay, so there's no specific answer to that. So our advice, we haven't set a timetable for agencies to do this by, because obviously agencies are going to take different time how much time it takes depends on the agency, the resources, and the level of interaction and risk. So we have issued the guidelines and the disposal authorisations already apply, but that doesn't mean that you don't have obligations from other requirements. So that legislation that I just talked about, if you don't put in place what your reasonable steps are to prevent that, then you're placing those vulnerable people, or in that case, that legislation relates to children, you're placing them at risk. And if something happens, there'll be issues. So there's no specific date requirement by us, but we would say start taking steps to resolve it.
I think our other piece of advice too would be that it's not a one-off. Yeah, I think in both the examples Julie's talked about and what we've talked about, it's an ongoing conversation and an ongoing refinement of expectations and what can be kept and what should be kept. We've got a couple of really good questions in the chat box, so I might just jump into those if that's all right. Okay. So, Angela, you've got a specific question around GRDS 1559. The trigger for that is a specific date, and so knowing how long these records is going to be important. And your question is it really going to take this long to decide? Okay, so Angela, you must be talking about the fact that the corroborating evidence needs to be kept till December, needs to be kept for 10 years. Yeah. Troy, did you want to answer that one?
Yeah, so I think it may not necessarily take us that long, but the reason we've chosen that date initially is to align with the National Redress Scheme. So that runs for 10 years. And really, I guess what we're thinking is to be able to, I know we don't have a list of records at the moment that the agency should be keeping, but what we're thinking is over the time of the National Redress Scheme, we'll hopefully be able to get a bit better idea of what type of records are being requested and what type of records are being used in these redress claims. And by doing that, we might be able to tie down to, I guess, a little bit more of a defined list than what we have at the moment, which isn't much. So that's the reason why we've chosen that date. Might we be able to, look at that sooner potentially? But again, at the moment, that is why the date's chosen. And it's interesting that the Royal Commission, the Recursive Royal Commission itself, recognised that uncertainty exists in terms of what records need to be retained about protecting individuals' rights and that type of thing. And the Royal Commission ran for 5 years and they still weren't sure. So I think that gives an indication of why this is such a tricky area and why we probably do need to have a bit of time to be able to see what is being requested and what's being used.
Oh, perfect. Thanks, Troy. Nancy, you've also popped another question into the chat box. So all your clients are considered vulnerable. So how does this then translate to what you're actually required to keep, or what Nancy's organisation is actually required to keep? Troy and Julie?
So I think it gets down to that it is tricky. So with Nancy's organisation, with organisations like Health, for example, the majority, if not all, of their clients could be considered vulnerable. So I think that's where, as Julie was mentioning, looking at the risk assessment in terms of what's the potential for abuse occurring and determining, I guess, what the risk appetite of the individual agency might go to help in identifying that. And again, it isn't just something for the records areas of an organisation to decide. It is something that needs to be part of broader strategic discussions and really driven from the top in terms of what risk appetite is and what resourcing might be available to throw at this. Julie, did you want to add anything?
Yeah, I think it's linked back to the risk assessment. I hate to do that to you, Nancy, but it's also about, do you need to keep all the records of the interaction with that client, or is there, key records that could help? Like, do you need to keep everything, or is it more about some specific records in dealing with that client that you need to keep?
Perfect. Thanks, Julie. Thanks, Troy. David's got a question here about anything as a result of the inquiry outcomes happening in agencies outside of record keeping that we could trigger off. And if I could jump in with this one, I'd say, David, in this instance, absolutely. I think any of the initiatives to either refine processes, streamline processes, putting in place new systems, they're obviously touch points where record keepers should be looking to leverage and make sure that they're involved. Julie and Troy, have you got anything else to add to that?
I'd agree. Just in terms of, when we've just, for example, looking at the legislative changes that are taking place, they're not just about record keeping. Record keeping will be a component of them to assist agencies. But and more generally, the Royal Commission had over 400 recommendations. So there will probably be a lot of touch points, if not already, but coming up for agencies in terms of actions that they're going to be needing to take coming out of that inquiry.
And I'd also be looking for, are there any good case studies where someone's done something fantastic that others could, copy from or learn from? So Justice and Attorney General passed those legislative amendments through. They led those. So as agencies then start to implement them and change their processes, can we get people to do case studies that shows the processes that they went through, so that others can learn from that?
The other thing I was thinking too was, is there anything like the Public Service Commission, Office of the Information Commissioner, Queensland Audit Office, are they doing anything? So instead of us just doing record keeping thing, is there other things happening at a whole of government level that we can sort of go, okay, it makes it easier for agencies if we can all get together and leverage off, Public Sector Commission if they're doing stuff in a HR space or anything like that?
Okay, so I'm not aware that there's links with the Public Service Commission, OIC or QAO at this stage. That doesn't mean we couldn't reach out to them and say, do you have any advice, or do you have any intentions of, for example, doing audits on these, or whole of government advice? But we can reach out and see whether there's any intention to do that, David.
And probably also, so Department of Premier and Cabinet is leading Queensland Government's overall response to the recommendations coming out of the Royal Commission. So, and it might be that those organisations either haven't started yet or haven't publicly announced what they're doing with recommendations, but it is something I think we can follow up with.
And we should also add that, so recommendations 8.1 to 8.4 were about government. 8.5 is also about going beyond government to the non-government schools. So it's about Department of Education and QSA working together to look at how our advice on records management can be incorporated into the non-government schools. But that's the link. It's non-government schools, not the community more broadly.
Perfect. Hey, thanks for that, everyone. Hey, we've got 10 minutes to go and we've got a couple of questions, so we're going to run as fast as we can. So Hannah's asked us if physical source records be destroyed. Sorry, English is clearly not working today. Can physical records be destroyed essentially if there's a digital version available?
The answer is maybe. So we have the source records disposal policy, and there are a number of criteria that have to be met. So, for example, the record, it can't be a permanent retention on that record. It can't be subject to a disposal freeze or legal action. Or there's a few little criteria like that. You need to have a digitisation disposal policy in place within your agency. But assuming that you meet the criteria, then yes, they would be able to. They could be disposed of.
And again,
you would need to make sure you're keeping them somewhere really safe, though. So if you've got your allegation, your permanent records, you can't. You could digitise them for easy access, but not disposal. And your records that need to be kept for 100 years on the allegations and investigations, you'd need to make sure that they're accessible for 100 years. So you have to have your system, no issues with someone accidentally deleting it, all those sorts of requirements, which is part of what Troy was talking about for your policy.
And I was just going to jump in and say, making sure you capture the decision. Say, hey, we've applied the policy in this way with these interpretations is probably really important in that instance as well, Hannah. So Christy has asked about, in a situation where a facility is managed by a contractor, what is the agency's responsibility to ensure the contractor has processes in place? And what's your responsibility in ensuring that they are identifying record creation gaps and implementing process changes to fill those gaps?
Well, we would say anything where it's sort of outsourced or contracted out, you can't outsource or contract out your record keeping responsibilities. So you need to make sure that your contracts between the council and the pool person running the pool or organisation, covers some of these issues as well.
Yeah.
Absolutely, and contractual arrangements there, I'd absolutely agree, are probably the best way to ensure that those obligations are met. I'd also add to that, if you put an obligation in place, just make sure you check that people are doing it. So it's one thing to have the obligation. It's completely another thing to make sure that it's actually happening, and then have the contractual mechanisms to be able to rectify things. And so just lastly, Owen, we'll take you as the last question. So your question is, should we be more actively monitoring precedent-setting case law rather than simply relying on a retention disposal schedule? So, for example, commissions of inquiry, criminal cases, investigations are likely to identify new or immediate risks and how they impact vulnerable people. I mean, my answer would be absolutely. I think keeping an eye on what's happening is a great idea. Troy, Julie, what do you think? What are your thoughts?
Yeah, we agree.
Yep.
It would be, as I said earlier, you need to monitor and review all the time. Don't just leave it operating in the background. Have you got new services? Have your risks increased? Did you actually have allegations and an investigation? And what are you going to change to do it? And then our definition of vulnerable person is quite broad. So when there is some case, or you see a case separately, and you think, well, what does that mean for us? Yes, we should be monitoring. And QSA would be looking at things too, where we think, okay, if we haven't captured those records, do we need to change some retention periods too?
Perfect. Thanks, Julie. So last one. So Sarah, you're going to be last. But if you've got anyone that does have any other questions, I encourage you to pop them all in. We'll try and get to them over the next couple of days just to get everybody an answer. Is there any clear advice on retention of records relating to grant applications if their funded activities involve vulnerable people?
That's a good question.
Yeah. I guess it is a good question, and one we might have to get back to you about, Sarah. But again, I think looking at our advice in terms of, well, what's the risk assessment with those records from that activity? So will the activity have risk of abuse occurring, for example, and then that might mean that the disposal authorisation for that particular activity might be that 1559 retained until 31 December 2028 at the moment. But yeah, it might be something we think about a little bit more.
Oh, great question. Thanks, Sarah. And look, on that note, I might hand off to Troy just to round us out for today, if that's all right.
Yep. So I guess just in summary, really quickly, we just wanted to close off with a few key takeaways from today's webinar. And probably number one is, regardless of our new advice, all agencies should already be managing their interactions with vulnerable persons and minimising risk of abuse occurring as part of good governance and as part of being a good corporate citizen. As we've mentioned a few times today, these changes are not just record keeping issues, but they should form part of a broader strategic approach to how your agency interacts with clients. Public authorities already have common law requirements to take reasonable care for the safety and well-being of their stakeholders. And so QSA's guidance, I guess, just takes that step of reinforcing, these legislative requirements from a record-keeping perspective. And again, as we've mentioned, with over 500 authorities in Queensland, as we've discussed, there isn't a one-size-fits-all approach, unfortunately. And like I mentioned, the Royal Commission itself, even after 5 years, realised that there's uncertainty in terms of what records may be required. But there might be similarities across sectors, for example, so across the health sector, across local government, universities, education. So if it's possible for those groups to get together to start to discuss what a common approach might be, or a bit of a playbook of options, well, then that would be a good approach, and that could be something that, if you get those groups happening, we could get QSA involvement on board, and we could go from there. But I guess as a starting point, what we're recommending is that agencies put the issue on the strategic agenda. So it's not just a record keeping issue, and take a risk-based approach to identifying the best evidence of interactions with vulnerable persons. So I hope that's helped in terms of putting a little bit of the QSA advice into context. But certainly some good questions today, and if you have any more, we have contact details on the following slide to send them through.
Perfect. Thank you very much, Troy. Well, on that note, I think we can end our today's proceedings. Thank you so much for everyone that joined us, and special guests from Queensland State Archives, Troy and Julie. We really appreciate your insights, and thank you very much to our other partner, Dr. Vanessa Douglas-Savage, for her interesting takeaways and insights in specific related vulnerable persons guidance.
Well, it's been a pleasure.
Thank you very much, all. We'll end recording there. And as I mentioned previously, we will share all the content from today's pack and a copy of the recording.
Thank you, everyone.
Thank you.
Thank you.